Just going to first walk us through here the topics that we're going to be covering today. As you can see, it's going to be a lot of information spread rather thinly. So please bear with us as we try to cover as much as we can. We may be going a little bit quick, and the general intention here is not to do a deep dive into any of these particular topics, but to give a general overview and sort of a foreshadowing of some of the issues you're probably going to be dealing with on a more regular basis, and you already have been dealing with in 2023. So the first topic we're going to cover is posting requirements, and this gets a little confusing because there are also posting requirements discussed in the transparency laws, which is the second topic, but these are posting requirements that have changed a bit in New York recently related to the kinds of information that you used to see or that you still may see outside your break room or outside your HR office or by the time clock, that kind of thing. We're going to talk about pay transparency laws. That's obviously a big one for a lot of us now. Quick, fast changing environment in that area. Talk about some interview best practices and rules around interviewing. Faculty diversity plans, something some of you are probably sick of hearing me talk about from last summer. AEDT, and I'm not even going to try to remember what that acronym is. I don't want to offend any sentient machines out there, or if Skynet's watching, I don't want to get myself in trouble, but it's basically AI technology that assists employers during the hiring process. We'll talk about some of the rules around that are just developing now. We're going to talk about background checks, some issues that are specific to faculty hiring, some general onboarding issues that are primarily relevant to faculty, but also staff, and then some issues around student workers, particular issues that are changing. So to help us work through this and kind of give us some context, some sort of a framework to work through on this, we did develop a hypothetical to work through. So I'm going to kind of get us started on that, and then I'm going to hand it over to Lisa. So in our hypothetical, we have Dean Lumberg of Hudson University, who wants to hire a new visiting professor of human resources management. Lumberg goes to the university's HR department and says that he's going to pay this new position in accordance with qualifications, and that the position may teach some on-campus courses, but will primarily be assigned to work remotely. Lumberg says, hold off for now, though, because I've got a buddy, I've got a guy I know who may be interested in taking the job. All right, so one of the things I'm going to pass it off to Lisa here to sort of go through some of the issues that this hypothetical raises, and some other issues as well.
Thanks, Seth. Good afternoon, everyone. So as Seth mentioned, today we'll be covering salary transparency laws. I'll delve a little deeper into the New York State and city ones momentarily, but they are also throughout the state. Albany, Westchester, Ithaca have them, as well as nationwide. And there is a New York State amendment, which I'll also explain in a bit, that passed the New York State Senate yesterday. And we also have a proposed New York City amendment, which I'll get into a little bit further. That's in its earlier stages. Other considerations when you're posting a job are web accessibility if your advertisement is digital. And just one note on this, because it's employment related, it will likely be OCR, DOJ together, some combination thereof. And OCR has taken a renewed interest in web accessibility cases, so it's something to be mindful of. You would also be deciding on work location and whether you would consider remote work. Many laws, first of all, for the salary transparency laws that would apply, but also there's many local laws past the hiring stage, past the interview stage when you get to hiring, that depend on the location that the employee is working from. So that's something to consider as well. And then within the postings, we'd want to avoid certain language, one that could indicate a discriminatory hiring preference, and also something interesting in the New York City Fair Chance Act, which my colleague will delve into a little bit further. Unsolicited neutral statements pre-offer are not permitted. And one example given in the guidance of something we should not do is not mention compliance with New York City Fair Chance Act on your job posting. It's a bit counterintuitive, so it's something to be mindful of as well. And for the New York State Salary Transparency Overview, so that has passed. It goes into effect September 17th of 2023. It requires to post compensation or a range of compensation, and as well as posting this within good faith and the employer's honest belief that this is what they would pay for the position. And for commission-based positions, you can fulfill this requirement by adding a statement that the position will be paid solely upon commission. You also need to disclose a job description if one exists. Retaliation is prohibited. Remember that it applies to both applicants and employees. There is a provision that it does not preempt local law, although I think Westchester might leave a bit of an open question because that salary transparency law does allow for preemption on the day that the same or substantially similar state law goes into effect. So that remains to be seen. And right now, the scope is pretty broad. It covers any job that can or will be performed in whole or in part in New York State. And there is a current record keeping requirement. However, under the salary transparency amendments that I mentioned passed yesterday, this is a chapter amendment pursuant to Governor Hochul's approval memo, which is a fancy way of saying it is very likely to pass. This would eliminate the records keeping requirement. A prudent employer might wish to keep records anyway, but would not be required to do so. It would change the geographic scope of the coverage, and specifically for remote work, you would have to report to an office supervisor or work site in New York State. I do think there remains a slightly open question of what if the company is headquartered in New York State, but the employee directly reports to a different office, because we all report to our boss's boss, so to speak. So we would advise to consider coverage very broadly. And the amendments would also define an advertisement as to make available to a potential pool of applicants for internal or public viewing, including electronically, a written description of an employment opportunity. Okay, so the New York City salary transparency law covers 4 or more employees with at least one in New York City. This has been in effect since November 1st of last year. Employers outside of New York City should also consider their remote workforce, because you do not need a brick and mortar location within New York City to be covered. And here as well, we also define working in New York City very broadly. For example, if somebody works physically during the 9 to 5 in Westchester, but then comes home and takes calls and emails in the evenings from their New York City home, we would not say that that's not working within New York City. Under this law, employees have a private right of action against their current employers. There is a right to cure for this commission complaints. If within 30 days of service of the complaint, the employer can prove to the satisfaction of the commission that they have cured the violation. The positive here is that would result in a $0 civil penalty for the first violation if the commission accepts the proof of cure. However, the downside to consider is that this is also considered an admission of liability for all purposes if accepted. And as I mentioned, New York City amendments may be on the way. They're in the early stages. One big change here is it would essentially transform the city salary transparency law into a salary disclosure law, but we'll keep you posted on that as it moves forward. Next slide, please. So you've posted your job, you've complied with all the salary transparency laws, you have a wide pool of applicants, you've picked your interviewees, and you're now at the interview stage. So just a quick reminder here that reasonable accommodations in many circumstances are available to applicants, and some new notes on that. The EEOC released guidance recently on hearing disabilities that expressly covers applicants. The religious accommodation standard may soon change under Title VII, because the United States Supreme Court accepted cert in Graf v. DeJoy, which is scheduled to be argued in April. And the Pregnant Workers Fairness Act, which goes into effect this summer, also includes applicants within its definition of employees. And just some quick notes on interview questions and hiring decisions. Remember that there are salary history bands in effect. The state has one, localities have them as well. And though it is much more nuanced than this, I think as a general rule to follow for the interest of time is to stay away from anything touching on a protected characteristic in an interview question or in a hiring decision. And then also a reminder that Title IX does cover employees, and the Second Circuit, in this Cornell decision over the summer, held that there is a private right of action under Title IX for a university's intentional discrimination, gender-based discrimination under a faculty member. And also just don't worry about writing this stuff down, because we're gonna share the slides. And a note also that the New York State Human Rights Law was amended around the holidays to include citizenship and immigration status as protected classes. Next slide. And finally, before we get back to Professor Lumberg, just a note on required postings. The state labor law was also amended around the holidays to take immediate effect to require digital copies of required federal and state postings, and also requiring a notice that documents required for physical postings are available electronically. Now, this can be accomplished in a number of ways. It can be accomplished through email, it can be accomplished through the website, and it can even be accomplished through an intranet. However, considering applicants, we would advise to put this on your public-facing website, in that many interviews are now conducted remotely and applicants won't necessarily be passing through your physical office space. And applicants must have access to certain required postings. I've included some examples here. Next slide, please. So back to Professor Lumberg. The university did not hire Lumberg's guy and instead posted the job because the HR department at the university was very smart and understood that this would raise certain equity issues to only bring in one person that Lumberg knew that happened to be the same gender as Lumberg. So they've now posted the job with a salary of 60 to 80, primary location on the Westchester campus of the college with superior written and oral communications ability required. So on the salary range, I think that sounds fine as long as it's posted in good faith. It's a nice tight range, so that's a good indication of good faith according to a webinar I attended with the City Commission. The primary location being in Westchester, to me, says that there is also an opportunity for this job to, or some responsibilities of this job to be fulfilled remotely, and that takes us back to the remote work considerations and the considerations of other salary transparency and other hiring laws. And as far as superior written and oral communications ability being required, this would take us back to avoiding potentially discriminatory language on job postings, because even though this sounds like it could be a neutral statement, it is, if you think about it, ableist language that might have a negative impact on someone with a speech impediment, a hearing disability, or a related disability. So we have 15 applicants for the position. That's a pretty small pool. And Lumberg goes through the applicant list and picks out his 5 favorites who all happen to be the same gender, happen to be athletes, happen to have a connection to him, and presumably if they went to college at the same time that he went to, are probably around the same age, perhaps. So I think this raises some equity issues, some diversity issues, and DEI and HR should recommend, in my opinion, to repost the position, maybe even consider a higher salary range or added benefits and see if they get a better pool of applicants. So I'm going to turn it back to Seth now, who's going to cover faculty diversity plans.
Thanks, Lisa. Excellent. You moved quite quickly. You could tell that was you've been listening to me talk too fast, too long, but yours is much more rehearsed than mine generally is. So I appreciate it. You fulfilled our promise so far of delivering a lot of information. I do have a question that came in that I think I'm going to try to address through this piece of the presentation. And the question is, every few years or so, we want to rehire an adjunct to teach a class they've previously taught. They're a private institution with no union. Do they need to post the job to have the person apply, or can they just rehire the position outright? And I think there are a couple of areas. There's no requirement that the position be posted. This kind of harkens back to the part of our hypothetical where Lumberg wanted to hire his friend rather than post the position. So there's no hard, fast requirement to post a position, but you do certainly want to consider what impact that hire may have on your institution's overall diversity goals, on your faculty diversity plan. If this is a private institution, so presumably they submitted one as a requirement of receiving Bundy aid if it's a New York institution, and they would have submitted a faculty diversity plan and goals. They're going to have to do that again next year, and the year after that, and the year after that. And you're rehiring the same adjunct may not move their diversity goals in the direction that they want to move them. If they are a federal contractor, they may also have affirmative action requirements under OFCCP regulations. If they have underutilization in the department, for instance, rehiring that same adjunct over and over again may not do anything to address that. It may, depending on who the adjunct is, it may help those their faculty diversity numbers or overall institutional demographics and utilization rates. So it kind of depends, but for the most part, I think for most purposes, casting that net wide, sometimes specifically targeting that the postings so that they reach the most diverse potential audience that you can is going to be the best practice. And then looking at that diverse applicant pool and working within that is going to get you where you want to be in most parts or in most scenarios. All right, so back to our hypothetical. After arriving at a satisfactory applicant pool, Hudson University invited the applicants to campus for interviews. Dean Lundberg was very excited to use the university's new HireBot software program to help him decide on the right candidate. Interviews were scheduled for May 1st, 2023. This would be HU's first use of their HireBot program, and no information about HireBot had been provided to any of the applicants prior to its proposed use. What should HR tell Lundberg in this situation?
Okay, so for those of you who are unaware, the New York City Council actually introduced a law that effectively regulates the use of artificial intelligence in hiring, promoting, and other employment decisions. We're going to refer to this as AEDT, Automated Employment Decision Tools. And it's because it's a New York City rule, it really applies to New York City residents. It does not matter if the employer is not in New York City. So that law became effective January 1st of this year, but it's not enforceable until April 15th, unless of course they move that. And as the slide says, it will likely be enforced by the New York City Corporation Council and presumptively also the New York City Commission on Human Rights. And the purpose of this rule is to ensure transparency in artificial intelligence usage in employment decision-making, so as to avoid discriminatory effects, whether they be intentional or not. So you can go to the next slide there. So defining AEDT is a bit tricky. So for today's purposes, we're going to go over the rule, the law as it's drafted today, the way it's formally drafted. And the way that the law defines AEDT is any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence that issues simplified output, including a score, classification, or recommendation that is used to substantially assist or replace discretionary decision-making for making employment decisions that impact natural persons. So basically the rule for using these kinds of tools is that it really can't be used unless the tool has been subject to a bias audit within the last year and a summary of the results of the tool, including the date that the results have been made available, of that most recent bias audit and its distribution data, such as selection rates, impact ratios for protected characteristics. Those have to be made publicly available on the employer or employment agency's website. Those are the rules for using the tool at all. But there's also a notice requirement that candidates and employees that employers have to watch out for. So Seth, you can go to the next slide. Seth, you can go. Oh, perfect. Thank you. Sorry. So basically the notice requirement, it requires employers and employment agencies to satisfy these notice requirements, again, for New York City residents, at least 10 days, 10 calendar days before the AEDT is used on that candidate or employee. They need to be informed that an automated employment decision tool, an AEDT, will be used in assessing that candidate and the job qualifications and characteristics that the tool is going to use in its assessment. So just a note, this notice has to also it has to include language that informs a candidate or employee how to request an alternative process or accommodation should that candidate or employee not want to be subject to the assessment of the AEDT. That's the way the law is drafted right now. And I'm going to stress this because in September of last year, a first round of proposed rules was introduced by the Department of Consumer and Worker Protection. And then they had a public hearing where approximately like 200 people came and commented. And as a result of those comments, because even the way that the law is drafted right now is very vague, even under the first round of proposed amendments, if you will, it was still pretty vague and people still didn't really know how to comply with it. So the agency came out with a second round of proposed rules in December. And basically the definition of AEDT changes under these proposed rules, how to go about complying with these notice requirements, where you want to put it, what language might need to be included. That's also likely going to change before April 15th. However, under the proposed rules, no such accommodation is required to be provided. It just needs to include language that would inform a candidate or employee how to request such alternative process or accommodation. So you can go to the next slide. So right now, the best way to go about complying with this is really you want to speak with your local council to determine if your AEDT actually qualifies under these rules and the proposed rules, because the proposed rules, neither round has been formally adopted into the law. So you want to stay abreast of the final publication of the rule. Here at Schoeneck King, we're going to stay abreast as well, because it's very likely going to change before its enforcement date. And even consider searching for an independent bias auditor to conduct that audit, if it's applicable, pursuant to the final publication of the rule. And even consider using contacting the AI vendor you currently use to see if they are already employ bias audits, which may be shared by the employers. Under the latest round of proposed rules, the agency suggests that employers might be able to share the AI vendor's audit, but that depends. Again, it's going to depend on the employer, the tool that you use, and it's going to depend on a lot of changes that we're anticipating. So that's how we recommend preparing for local law 144.
We had a question come in that should we be rethinking our applicant tracking system? I don't think, let me try. I don't think we know enough right now, but I wouldn't think so. But since the applicant tracking system isn't actually helping in any decision making, it's more of a record keeping process, as I generally understand them to be. Is that consistent with your thinking as well?
Yes, it's a little early to tell who this even applies to right now, but yeah, I would agree.
So stay posted, but right now, probably okay. All right, back to our hypothetical. Dean Lumberg chooses Michael Bolton, PhD, for the position. As per Hudson University policy, a background check is performed on Bolton. The background check determines that Bolton had a 1999 conviction for vandalism related to the destruction of an office printer. What does HR need to do with this result is one of the questions we're going to be looking at here in a minute. And then the conviction is ultimately confirmed by the background check company. And Dean Lumberg says he doesn't want to hire an ex-con to be on the faculty, and he wants to move on to another candidate. So another question we're going to be looking at is, can Hudson University or should Hudson University hire or refuse to hire Dr. Bolton based upon this past vandalism conviction in 1999?
Okay, so with respect to background checks, and we're going to go over this very quickly because, it's our understanding that many employers are already complying with some of these rules. Like, for example, the EEOC guidance, which is you always want to apply your background checks equally. You don't want to give a background check to just women and not the men. You want to give it, provide it equally. Under the Fair Credit Reporting Act, there are certain requirements before you even get that background check. For example, you need to disclose the possible use of the results of the background check to the candidate or employee. You need to provide the option that a candidate or employee might be able to review the nature and the scope pursuant to the investigative report provided by that background check company. And 3, you need written permission to do that background check. Usually this is often done by that third-party background check company, but just reminding you guys. Also, you want to keep in mind the New York State Correction Law 23A. Effectively, this prohibits employers from unfairly discriminating against persons convicted of criminal offenses and requires employers to evaluate qualified job seekers and employees with convictions fairly and on a case-by-case basis. Should you seek to consider, if you're considering taking an adverse action based on a background check, this law actually provides for an 8-factor analysis that one would need to look to. before they, engage in that, possibly refusing to hire someone or any kind of adverse action. And for New York City, there's also the New York City Fair Chance Act, which prohibits most private employers from inquiring about applicants, including employees and unpaid interns, inquiring about their criminal histories until after a conditional job offer has been made. And it's a little similar to the New York State corruption law in the sense that if you intend to take an adverse action based on the results that the employer has received from that background check, there's a separate analysis that is actually publicly available to employers. It's the New York City Fair Chance Notice that has its own separate analysis, separate from the New York State correction law that you would want to look to before you engage in that action.
Thank you. So just looking back at our proposed questions here, what would HR need to do? They'd need to refer the individual back to the background check company, generally is how it would work, to verify the results and to potentially protest the results, say, no, it was my evil twin, not me. And then can HU refuse to hire Dr. Bolton based upon this conviction? Based on the information we have now and what we just heard about, I'm going to say the answer is probably no. You're talking about a very old conviction. There's no evidence of any criminal activity since then. It's fairly minor, I think, as things go, and it's unrelated. I think probably most importantly, unrelated to the faculty position that Dr. Bolton's being considered for here. So moving on. The university ultimately hires Dr. Bolton, and he negotiates himself a $90,000 salary in light of his pristine credentials. This is more notably than several longtime associate professors in the department currently make. I'll also note here that $90,000 is outside of the range that had been posted, the salary range that had been posted, as we discussed earlier. While that's permissible, you don't have to necessarily always stay within the range. You certainly want to stay within the range. It raises some questions. It opens you up to potential liability. But as long as that $60,000 to $80,000 range that was originally posted in good faith, I think this is permissible. But you need to document why you're doing it and make sure that you have good reasons for doing what you're doing, and you really want to consider reposting the position, because the fact is you're likely to get a different applicant pool if you had posted it as 60 to 90,000 instead of 60 to 80,000. So I think there are some real considerations there. It's not outright prohibited under the salary transparency rules, but would be highly discouraged, I think, by many of us who follow it. So then Lumberg assigns Bolton to several faculty committees and asks Bolton to serve as a PI on a grant application that the department was preparing to submit. The next week, Bolton attends the faculty senate meeting and introduces a resolution of his own expressing no confidence in Lumberg. So a few more things implemented or that are brought out by this particular part of the hypothetical. We want to think very deeply when you're making this hiring decision and talk to Lumberg, I think, as the HR professionals, about where this position fits within the overall faculty of the institution. A lot of times that's going to be defined sort of by the faculty handbook. It may not be defined alone by the title that you give the individual. Just calling someone a visiting professor may not be clear as to what rights that individual has. You want to look at how long maybe their contract is for, what their obligations are going to be. Do they have service obligations? Do they have research obligations? These are questions that you want to make sure are answered prior to the individual starting, or made clear to the individual, or made clear to the individual supervisor. Hopefully, those are going to be addressed many times by your faculty handbook, but you also want to look at departmental policies. It's not uncommon that the English department will pull out some bylaws from 1972 and say, well, what about these bylaws, these policies, and we need to vote on this individual before they can, and we need to vote them into the faculty senate, or we need to vote them into the department before they can work on a research grant or something like that. So you want to make sure that if there are departmental policies, you have your arms around those, you know where they are, you know what they say, You know that they've been properly approved and vetted by the institution to the extent that the institution has the prerogative to do that. But make sure that they are primarily, I think that the biggest thing that you want to be looking for with those departmental policies is to make sure that they are consistent with the larger policies, the larger direction of the institution that's usually going to be contained in the faculty handbook. So who is the person? Do they have representation rights? Do they have voting rights? Does Bolton in this case have the ability to serve on committees? Does Dr. Bolton have the ability to introduce a resolution in faculty senate? Is he a voting member or a member at all of faculty senate? Are there promotion and retention requirements related to his position? In other words, this can work both ways. So if he's there a certain amount of time, are there obligations that he be allowed to stay longer? Does it automatically extend his contract, for instance? Or are there limits to how long you can have somebody be in a particular title? So these are questions that you want to make sure you're considering, thinking about, making sure are consistent with how your faculty policies, hopefully again contained in a faculty handbook, and departmental policies that are consistent with those. Finally, we noted that the salary that was offered was greater than some associate professors, who generally an associate professor would be sort of senior to a visiting professor at most institutions. And we want to make sure that before that salary is offered, that higher salary, that you want to consider the effect it's going to have on the overall faculty. These are never individual decisions. The decision is going to have effects on the overall equity of the institution, on equity of what other people are making. There may be a regression analysis that's required, particularly in the tight job market. Less so for faculty in many departments, liberal arts faculty, not such tight job market these days. But in business, health sciences, it may be a tight job market, and you may be paying people more to get them in the door than you are paying current people to keep them there. And those are considerations that you need to be looking at before you make any kind of salary determination. Again, it's not an individual. It's the salary determination doesn't just affect that one person. It may affect the overall sort of fairness and equity of the department. Some other considerations here that are implicated by Dr. Bolton's hiring and that general scenario. You want to make sure you define the position. I have to give credit to my former SUNY employee labor relations colleagues who used to beat it into my head that you always have to be thinking about the pie. Oh, it's always about the pie and what slices of the pie count towards any individual position. What part is research? What part is service? What part is teaching? Generally, teaching is going to be the biggest part for most college and university professors, but there may be some at some institutions where they barely do any teaching and they're mainly hired as a research faculty member. Service, pretty much everybody's going to have to do that, but you want to make sure that that's clear, or you'll have people that try to get out of it or don't perform service, or are disappointed when they don't get that promotion or they don't get tenure because they didn't do enough service. So you want to make sure you're defining the position clearly, both for the supervisor and for the individual who is hired, and they know what the expectations are, and the institution knows what it's going to be evaluating the individual on. Are there funding limitations related to the individual's compensation? Is it tied to a grant? And is the grant tied to the individual? So does the grant funding need to come in order for the individual to make the salary that they're making, and vice versa? If you're taking the grant, do you have to continue to pay this individual and employ this individual? And will that have implications on things like potential employee discipline and evaluations and retention? Evaluation, obviously, you want to be clear about your evaluation processes, how those work, what the timelines are, who's involved, what the expectations are. Those are things that you want to set forth very early on and then adhere to as closely as possible. And I'll just mention here, mentoring is a big thing to talk about early. It's a lot of these things are not intuitive, right? For those of us who have been in higher ed for a while, we sort of throw around a lot of these concepts, like the pie I just mentioned. But for somebody just entering the profession, particularly if you're somebody who's coming in from, maybe an adjacent private sector area. They may not understand all these things. They aren't intuitive, and you want to explain them and ideally give them someone they can talk to who is maybe not their supervisor, maybe a senior colleague that they can work with. And I think that's particularly important. Most people recognize for tenure track positions, because ultimately that individual is going to be evaluated, and they want to know what those standards are going to be, what the expectations are going to be. But I think it's not unimportant for other positions such as visiting positions and even adjuncts. All right, back to our hypothetical here. Dr. Bolton begins teaching and hires a teaching assistant, or is assigned a teaching assistant, Joanna Aniston. And Joanna does not receive pay for her work, but she does get free tickets to lacrosse games. Bolton gives Joanna Protzi access to his university email account so that she can keep track of his students and help them respond. And while reviewing Bolton's email traffic, Joanna finds several messages that he has exchanged with Lumber, where they discuss giving some students better grades based on physical appearance. Joanna forwards these messages to the entire class. All right, bunch of things implicated here, obviously. Things that ideally were covered. There's no indication in the hypo whether they were covered or not, but we certainly have some violations of things that should have been covered. There would have been since we had something that looked very much like sex discrimination here, there would have probably been a mandatory Title IX reporting obligation. There certainly will be under the proposed regs. Whether Joanna would be covered under the current regs is a question, but she may be required to report it under institutional policy anyway. Make sure there's training around that. Dr. Bolton doesn't look like he received a sexual harassment prevention training, or at least didn't adhere to it if he did. Safety and security training, not really implicated by the hypothetical, but something you always want to be thinking about and talking about in this day and age, certainly, and making sure that new employees feel safe and secure and know where to go if they have an issue. Cyber, IT security, I'll just throw out there that our higher education practice group and our cybersecurity group will be presenting a series of webinars over the next several months on higher education, IT security, cybersecurity issues. It's a very hot topic right now, and for good reason. We are a target. We have been a target, and we continue to be a target of criminal cybersecurity breaches and activity. And everybody needs to be part of the compliance solution to that, including faculty members. Bolton giving Joanna access to his email accounts probably would not make his IT security folks very happy. There's some FERPA compliance questions there as well. FERPA is one of the, I encourage you, if you have counsel or invite one of us to come talk to your faculty generally about FERPA. It is so misunderstood and understood by faculty members. I can't tell you how many times I've seen faculty members cite HIPAA. That doesn't apply to them nine times out of 100 because they're not part of a covered entity, but they don't consider FERPA, which does apply to almost everything they do on a daily basis. So better privacy compliance training under FERPA, I think, is probably something that many of us could do, particularly with regard to faculty. I think staff are maybe often a little bit more enlightened in that area. And then look at your employee handbook and determine what are things in here that obviously the person has signed off on it. But what are things that we want the person to do more than just read in the handbook? What do we want to actually teach them about, tell them about, inform them about, train them about? There may be some relevant student policies in there that are important for faculty and staff to know about, particularly if it pertains to their job. They shouldn't be, they should be generally well informed about the operations of the institution and how certain rules apply to students. We want them to be sort of part of the institution, both as an educational aspect and to some extent, if necessary, enforcement. And faculty policies, obviously, as we've talked about several times, the faculty handbook, how that applies is going to be an important thing to not only give them and tell them to read it, but in some cases train them about how these things actually apply and how they've been applied and how the institution uses those certain aspects of its faculty handbook and policies. All right, we had some additional issues that were brought up by the employment of Joanna. who is a graduate student who is paid in, I believe we said, home field lacrosse tickets. There are very limited areas where are very limited exceptions to minimum wage laws, quite frankly, to FLSA and the New York State parallel labor laws that require you to pay people for the work that they do. Generally, graduate assistants, resident assistants, interns, people like that on campus may fit into some of these exceptions, but we need to make sure of that as we are employing them. I will say I worry a lot of times about clients overusing some of these exceptions. Obviously, lacrosse tickets would not be an acceptable form of stipend. Tuition waivers maybe, actual money stipends maybe, or credits that can be used. What you want to look at generally with regard to stipends, housing waivers, things like that, are that they support the educational endeavor that the student is there for. So there needs to be kind of a nexus between the stipend or whatever kind of remuneration that the individual is receiving and the education that they are actually there for, that the work is meant to supplement and support rather than be work for hire that needs to be paid in accordance with, like I said, minimum wage laws. Volunteer is another one. Volunteering is generally only allowed if it's done for a charitable type of purpose, right? It can't be done because somebody wants to get something for themselves out of it, like a job in the future. That's a classic one. Well, I'll volunteer now and hopefully they'll hire me later to do the same job. That's impermissible. You really want to be doing it sort of out of the goodness of your heart or of your interest in the institution and in furthering the institution, not for some not for some personal gain. To what extent do leave entitlements apply to your student employees? What happens if they get sick? What happens if they get pregnant? What types of leave are they entitled to? These are things you need to think about ahead of time. And there may be laws, there certainly are laws in most situations that are going to apply and give them entitlement to leave, just like they would have on the academic side concurrently. Workers' compensation in New York, generally, even unpaid interns need to be covered under workers' compensation insurance. That's just a fact of life. The Workers' Compensation Board has generally interpreted even educational benefits as income for purposes of workers' compensation law. Those individuals need to be covered under your workers' compensation insurance. I'll also note generally that benefits the institution. It gives them a sole remedy if they are injured while they are doing whatever they're doing, particularly if it's some GA who's working in a lab or something like that. There may be real consequences to the work they're doing, potential dangers related to that. If they are a resident individual, if they are, whether they be an RA or a resident employee of any other kind, sometimes visiting professors have residencies. You want to make sure you have a housing license that is tailored to them. Don't just give them the student license. It's got to be specific to them and it's got to be tied to their employment. That's a huge part of it. That if they lose their employment, they also lose their resident. And it's a license, not a lease. Intellectual property rights. If they're working with a faculty member, what are their rights, if any, to the intellectual property, to the copyright, to the patent that is developed as a result of that work? And finally, a big topic here on many campuses, particularly on the private side these days, is unionization of student workers, particularly graduate student workers. And so you want to be thinking about that ahead of time as you're making hiring decisions. How is that individual going to fit in the new CBA that's covered? What bargaining unit are they going to be part of? Is there a way that you can structure the job to make sure that they are covered in this one or not in that one? That as long as it complies with NLRB policies, obviously, which are changing, and our NLRB rules that are changing very, very quickly these days. You're keeping up with it, but you're thinking about it as you're making that appointment, as you're hiring that individual, how they're going to fit into your overall union environment on campus. And with that, I think we're done. We're out of time. I think we got to most of the questions, but you can always reach out to any of us about any of the issues that we've talked about today or anything else. We encourage you to do that. Thank you so much for coming. Sorry when a minute over. That's my fault as usual. And I want to thank my colleagues both for helping out today and for presenting on these emerging and important topics.